Welcome to Gracefully Greying. I am your host, Attorney Henry Gornbein. Please watch all of the Gracefully Greying series on the Henry Gornbein YouTube channel, and also tell all of your friends to watch as we continue to grow not only the YouTube series of Gracefully Greying, but also our soon-to-be launched website, gracefullygreying.com. Elder law is a very important issue for those of us who are gracefully graying or have aging parents. Today I'm pleased to welcome as my guest Samantha Falkner of the Cronin law firm as we discuss issues in elder law. Samantha, welcome to Gracefully Greying.
Hi Henry, thank you so much for having me today.
Well, thank you for having me. Let's talk about, first of all, what does the term elder law mean?
So elder law is really an umbrella term focusing on a series of issues that affect the aging population. So that can be anything from estate planning to Medicaid planning and asset protection and things like that.
Let's start in the estate planning will area. And what's so important is what people forget is a lot of celebrities didn't have a will. You have Aretha Franklin, who never did a formal estate plan. Mm-hmm. She wrote some handwritten wills, and there are disputes as to whether they're valid. You have Prince, who died with no will or estate plan. You have Elvis, who died with no will or estate plan, and we can go on and on and on. So Samantha, why don't you tell us a little bit about a simple will and what it does and why it's so important?
So it's crazy you mentioned that, because estate planning essentially can be very simple and effective. So the fact that celebrities like Prince are dying without a will or any estate plan is just mind-blowing to me. But a will is essentially a legal document that provides instruction to the somebody's family when they pass away on what should happen to their stuff, who should get it, when they should get it. A lot of times it tells who should be the guardian of the person's children, but in the elder population, that's not really important because their children are not usually minors.
What are the basic goals, I guess, are really to make sure that your last will and testament, which means what you want, is carried out. Isn't that kind of a simplistic version?
Yeah, that's very correct.
And what are the components of a will? I mean, you have, tell us about some of the things, specific bequests and some of the other issues that are handled by virtue of the conveyance of a will.
So in a will, a person will typically designate what they want to happen with their assets, whatever those may be. It could be personal property or real property. Oftentimes there are specific bequests, as you said, which is a specific gift of a specific item to a specific person. And that's important because a lot of times when somebody dies, they have unique relationships with each of their family members. So each person thinks they know what so-and-so wanted to happen with their stuff when they're gone. So there's information about gifts in there, anything that anybody wants done with their stuff, like real property, what should happen with the house. Should it be given to somebody as a gift? Should it be sold and the money divided? What should happen with the life insurance policy? What type of funeral does the person want? What type of burial or cremation services is that person interested in?
What is a personal representative?
The personal representative is an individual that's designated by the person who makes the will, and they are responsible for carrying out the wishes of that person after they die. So the will designates a personal representative, and that gives the court permission to authorize that person to make those decisions on behalf of the person that died.
Now, one thing we should clarify, a will does not avoid probate.
That's correct.
It's strictly a vehicle that helps ease the process and make sure that specific bequests, your designations, are handled appropriately. And another reason for specific bequests, often it's not only money, but it can be jewelry. You can say, my engagement ring is to go to this child, other items of jewelry to this child or this friend or relative. So again, these are important reasons why a will, and it should be clear, it can be changed And I think what we're talking about, Samantha, is it's my last will and testament. It's the most recent one because sometimes people, if someone's in or out of favor, they may be changing amounts or who, so you got to make sure that it's the most recent one, correct?
That's correct. And depending on when you start your estate planning, if you made your first will when you were 60 years old, then by the time you're 65 or 70, your wishes or your desires may have changed, and you can change it anytime you want to, which is a nice thing about it.
Samantha, what is a guardian?
A guardian is somebody who is put in place to make legal decisions for a person who has become incapacitated.
And this is court appointed?
Typically, yep. The court can appoint somebody. The person who needs the guardianship is referred to as a ward. So the ward can state a preference or even sometimes file a petition on their own behalf to appoint somebody as a guardian for them. It's typically a close friend or family member. If that person doesn't have a close friend or family member available, then the court can appoint somebody like an attorney or another professional to be the guardian for that person.
So the guardian does not have to be an attorney. It can be anyone who's, I guess, over 18.
Yep.
And why is it so important to have someone you trust in the roles of either guardian or personal representative?
So it's important to have somebody that you trust in that role because they have big decisions to make and actions to take on your behalf. So you want to make sure not only is that person somebody you trust where they're going to make decisions that are in your best interest or in accordance with whatever instructions that you've left for them, but you also want to make sure that it's somebody that's able to make those decisions on your behalf.
What's the difference between a guardian and a conservator?
The guardian is in charge of legal decisions for that individual, and the conservator is in charge of the financial aspect. A lot of times, the responsibility of the conservator often piggybacks on the responsibility of the guardian. It's often the same person, but it does not have to be.
Now, a will we've talked about. What is the difference between a will and a trust?
So the biggest difference between a will and a trust that I think is relevant to people in general is that a trust avoids probate.
Explain how that works.
So I like to think of a trust like a box. So you have the trust, you have this box, and while you're alive, you can put anything in the box that you want, any of your assets, or you can take it out. And the box holds your assets for you. And the trust is a set of instructions that go with the box that tells whoever is the trustee at the time, so during your lifetime, it's usually you're the trustee of your trust, but if something happens to you, you have a successor trustee. And that trust document gives the trustee instructions on what can and cannot be done with the property that's been put inside that box. So that document avoids probate. It's outside of the scope of the probate court unless there's some sort of issue.
So to clarify, the trust is in place, but the money has to have been put into trust before death, or could it be saying that the trust can take effect upon death and still avoid probate? And maybe I'm getting a little technical, but I'm trying to clarify this for our viewers.
Both. So
Okay.
We always recommend that you fund your trust right
Okay.
away. And as your assets or your financial situation changes, it's very fluid. So, if you have a mutual fund and it's growing and you want to, invest some of that somewhere else, or you have stocks or anything like that, you want to put that in the trust right away. But what you can do is the will and the trust can work together. So anything that you forgot to put in your trust that was meant to be in the trust can be poured over into the trust by your will. It's very complicated, which is why they have elder law and estate planning attorneys like me to help people navigate that. But the assets can be put in the trust during your lifetime, and if you forget to put something in there, your personal representative or your trustee can make property part of the trust after your passing.
Samantha, tell us about charitable contributions.
Charitable contributions are a tool that are used by many different types of people. First and foremost, people are often passionate about certain causes. Ones that I see a lot have to do with animals or meals for children and things like that. So it's a way that you can continue to contribute to a cause you believe in after your passing with giving to the charity. It's also a technique that's used with people with high net worth estates to help with the tax planning. Because there is a threshold of value that you can have for your estate per the federal guidelines before you're hit with the estate tax or the death tax, as people
What
call
are the amounts, if you know?
The federal guideline is $11.4 million. Michigan does not have an estate tax.
So you're dealing with, especially with a substantial estate, you have to look at tax issues as well as just how the money's going.
Yes. Yeah, and the attorney that's helping the person make their estate plan should be working with their CPA and or their financial advisor to make sure that the plan preserves what that individual has been planning for their wealth.
Samantha, what is a medical directive?
Medical directive is a set of instructions that indicates what type of care or amount of care that you wish to have. And it also designates who is able to make those decisions for you if you become incapacitated or unable to do so. So oftentimes it will indicate if somebody wants to be on life support, and if so, how long, or if they don't want to be on life support.
So it's do not resuscitate, so to speak, and I guess it's an individual choice. I know my wife and I, we would not want life support. We would not want to have a life that has lost all meaning, and I think most people that you talk to, is there a preference one way or another? I think it's an important decision, but what do you find?
It's a very important decision, and honestly, it's about 50-50. A lot of people are guided spiritually or by their religion in making those decisions. I see a lot of people that have the same philosophy that you and your wife do, that if there's no meaningful chance of recovery and you won't be able to live your active life that you were living before whatever happened, then they don't want their life prolonged artificially.
Let's start at a point where you have someone coming in about an estate plan. Is it usually parents, or is it sometimes parents with children? What do you find is more common? It's a good, in our area, it's a good split. We have a lot of the aging population that come in and either want to make modifications to or finally establish an estate plan for themselves. And we have a lot of younger couples that are just starting to have children and never thought they needed anything in place before they had kids. What is a typical discussion? Why don't you take us through it? Let's say I'm a prospective client for an estate plan. What happens?
Sure. So first, we have this great educational workshop that we host in our office a couple of times a month.
Tell us about that.
It's the 7 threats to your estate, and it goes through a lot of what we're talking about today. Different types of documents, how they operate, why you want them, things like that. And also, we talk a lot about how do you die, because how you die can really impact what happens with your estate plan or what type of protections you may want to have in place.
What do you mean by that?
So, for example, if you have a married couple and they have accounts with beneficiary designations, so you have a retirement account, mutual funds, things like that. So, when you die, it automatically goes to your beneficiary, which is usually the other spouse. So you have a husband and wife who are traveling in a vehicle, wife is driving, they get in a car accident, husband dies, all of his stuff goes to wife. Easy, right? But what happens if the person that wife hit also died? Now what happens? Their family's suing her, and they're going to get everything that she's just got from her husband. So it's not necessarily protected. So we talk about those type of things. Or if you have, an elderly couple, same type of situation, the driver was healthy before the car accident, but their injuries from the accident now put them in a situation where they require nursing home care. Well, now the nursing home's going to get all of your assets if they're not protected by your estate plan. So how you die is very important, and we never know how we're going to die.
No, we don't.
Usually,
we don't know what tomorrow's going to bring.
No, you never know. So that's why pre-planning is so important. But that's one of the things we talk about in our workshop. We have this folder.
Let's see what you have.
Yeah, we have this folder here.
Okay, the
a nice little Cronin Law Firm folder.
We're part of.
And there are several handouts that each attendee gets. Who needs estate planning? There's a little sheet on each type of document. Trusts. There's a page about probate and why you want to avoid it. There's information about Medicaid planning. And even how to pick the right professionals to help you. How do you know your estate planning attorney is the right one for you?
Well, what's the answer to that? You just raised a good question.
It's a good one, right? So what we discussed in our workshop is, how many questions is your estate planning attorney asking you? How many different areas of law are they touching on? Even just in the few minutes we've been chatting, Henry, we've talked about tax law, we've talked about estate planning, we've kind of glossed over some family law implications, other probate issues like guardianship, conservatorship. So your estate planning attorney should have knowledge of all of those things.
You want an umbrella. You want a broad base. You want as much protection as possible.
Exactly.
You mentioned earlier that often your will should state instructions. Do you want a particular type of funeral? Do you want a particular type of service? Do you want to be cremated? Do you want to be buried next to such a person? But the question I have, if it's in your will, it's too late. So how do you deal with that?
So one of the things we always recommend is having those conversations with your family members and making sure they're familiar with what information is in your documents before you die.
And these are difficult conversations. How do you get people to start talking about things? I mean, certain taboos, money is often a taboo, illness and death are taboos. So how do you get over some of these taboos?
Yeah, the topics are very taboo, and a lot of people do not like talking about, especially with an attorney. No one wants to come in and, talk about death and dying.
Sure.
And, but you have to explain to people, or people need to understand that while these conversations are scary and can be overwhelming, it provides an incredible peace of mind to their loved ones that are left behind when a lot of their questions are answered. Because when mom passes away, or grandma or grandpa passes away, or a spouse passes away, the last thing you want to be thinking about is what kind of funeral is going to honor my loved one that's no longer with me. When the instructions are laid out for your loved ones that are left behind, it makes it a lot easier for them to go through the grieving process and carry on and feel that they're honoring you and doing right by you as well.
Next question, what is a durable power of attorney?
So durable power of attorney means that the power of attorney survives your incapacity. So the power of attorney is valid while you're alive and also if you become incapacitated, but it extinguishes upon your death. Those are usually used to make financial decisions for you or healthcare decisions and access health information as well while you're alive.
You can leave a lot of assets, but you don't want to play hide and seek with assets.
Yes.
So why is it important, and how do you get people to come to an understanding where they should list assets, list debts, have perhaps bank account statements, information regarding vehicles, deeds, and perhaps information that there's a safety deposit box and where it is? How do you get people to put this together in a coherent list so that those who are loved ones, who are the heirs, know where they are?
This can be challenging, especially for the aging population.
So how do you deal with this issue?
Yeah, so we encourage people to keep just a running list and as formal of information gathering as they choose, usually some type of spreadsheet or even just a list on a piece of paper that they can add to. But it's important that They keep a list, or they can even keep like the most recent statement that they receive. A lot of people still receive statements in the mail, or a list of their online banking login information with their estate plan, so that whoever is appointed as the personal representative or successor trustee can easily access that information after they're gone.
How do you get people to talk about it, especially if you're dealing with parents who really are secretive and children who are going to be the heirs and will be probably handling the estate?
Just stressing the importance of that to them, even if they keep it with the estate plan and they don't talk about it with their loved ones during their lifetime, then they'll know that it's not going to be a wild goose chase to try and figure out where their assets are or what they are. There's also a questionnaire that our clients fill out.
Tell us about the questionnaire.
The questionnaire, it designates what all the wishes are of the client and gives us information, like personal information, identifies their relatives that they want things, or friends that they want things to go to. But it also has a space for listing these types of financial accounts. So at the very worst case scenario, their loved ones can call us, because our information is on the estate planning documents. So they can call us and say, hey, Mom said she had this, but I can't find it, and we can at least give them a starting point if there was no list kept from time.
Samantha, we talked about the initial consultation. What other steps are there? I mean, is it a one-stop process, or is it several steps?
It's several steps. It's very involved because it's big decision making for a lot of people.
Well, take us through it.
Okay, so we have our workshop, which we went over. That's our first step. And there's a questionnaire, which we also talked about. So the questionnaire is filled out, the workshop's gone on, and the workshop's educational. So that saves people time later, and it gives them the information they need to make their best decisions. So after the workshop and the questionnaire, they'll come in for an appointment, and we'll have a planning meeting. And we'll plan with them what they want their estate plan to look like based on the information they got in the workshop and the information in their questionnaire.
What if they don't know?
We work with them through it. Yeah, our planning meetings usually last an hour or so, and if it takes more than one, it takes more than one.
And then what happens? Well, at some point you have to be retained. So you're retained probably at the first consultation, or what's typical?
Typically after the workshop.
Okay.
Yep, typically after the workshop, then the clients retain, we give them the questionnaire and they fill it out, and we go from there. Then we plan what everything's going to look like, then we prepare the drafts, then the client has a chance to review the drafts, we make any changes that might be necessary, and then we have a signing meeting.
So typically, and let's go through this now, there's going to be a will.
Yes.
In most instances, especially where things are more complicated, you want more control, there's going to be a trust.
Mm-hmm.
There's often going to be a durable power of attorney.
Yes.
There's often going to be a medical directive. What else? What am I missing?
Let's see.
A list
sometimes
of
there's
assets
deeds
and
that need to
liabilities
be
also.
prepared.
I'm sorry?
Deeds sometimes need to be prepared if you're
Okay.
transferring property into the trust. And with the medical directive, there's also a healthcare power of attorney, because the medical directive is sometimes referred to as a living will, I think is what you're talking about.
Sure.
And that's not necessarily, the law in Michigan does not necessarily guarantee that that would be followed, but those same instructions can go in the durable power of attorney for healthcare.
Why wouldn't they be followed? What would be a reason where they wouldn't be followed?
The law is just iffy on that in Michigan. So Michigan likes more defined, clearly stated, clear intention, clear direction.
So when you're meeting with someone, you want to make sure it's clear that, they don't want to have any unusual procedures, they don't want anything unnecessarily done, or unless they want to say, whatever it takes, do everything possible. So I guess there are two ends of the spectrum, for lack of a better word.
Yeah, people are either very detailed in what they want or more general in what they want.
We're down to 1 minute, Samantha. Give us 3 takeaways before we sign off.
Okay, so first and foremost, don't be afraid to have those tough conversations with your loved ones and your family members. It's very important that you talk about these things out loud. And my takeaway number 2 is talking about things out loud, whether it's with your religious leader or a friend of yours or an attorney or a family member, helps you clarify your vision for what you want to happen in your estate plan and how you want those things carried out, or what you want for yourself with the medical directive and things like that. So having those conversations helps you clarify what your vision and what your goals are. And 3, pre-planning is always better than crisis planning. So it's never too early to start planning, and you can always change your plan if your life circumstances change.
Yeah, we don't want people who end up like Prince or Elvis, or, planning is important.
Yes.
We're out of time.
All right.
Samantha Falkner, I want to thank you so much for being my guest on Gracefully Greying, and I want to thank you for watching Gracefully Greying.